Hi everyone, my name is Beverly Allen. I am a Tacoma-based family attorney. I am also a Reserve Corps judge advocate for the Washington Army National Guard, where I serve as a captain. And that's relevant because I'm going to be presenting issues on the Service Members Civil Relief Act. However, this is the words in this video are my own and my own opinions. I am not speaking for the Department of Defense or the Washington Army National Guard or the JAG Corps. I am speaking solely on my own accord. However, I'm also using Army training materials. So with that caveat that the materials here are Army training, but the opinions are my own, I will share my screen so that you can see the slideshow that I've prepared. Now, this is not the standard training package, although it does say that. I indicate here that it's been modified for the Pierce County Law Library's Vibrant Community Series, which is what we are participating in now. So without further ado, the Service Members Civil Relief Act, or SCRA. This is a set of federal legal protections that cover service members and protect them from things like default judgments. Also different provisions come into play, such as lowering interest to 6%, and such as giving soldiers and service members the ability to terminate leases or other contracts when they are mobilized. But for purposes of this presentation, what we're talking about is default judgments and how soldiers and other service members are normally protected from default judgments, and how also you should proceed if you are trying to move forward with your case and the other person is a service member. So there's going to be a bit of a background here on the SCRA, as well as a description of who receives the protections, when they begin and end, and some of the protections and benefits. For this slide, we are focusing on the procedural protections only. All right, so the background of the Soldiers and Sailors, or the Service Members Civil Relief Act. It used to be called the Soldiers and Sailors Civil Relief Act in 1918. That was amended again in 1940. That version continued to 2003, was amended again, changed to the Service Members Civil Relief Act, and there were additional amendments in the various years below on your screen. So in general, as I've already said, it provides various legal and financial protections to qualified service members during military service. It's meant to protect the force so that they can focus on the military mission and not on civil legal issues that might potentially get in the way. And that's what that second bullet point is about. Also, as an aside, that is what the JAG Corps Legal Assistance Team's mission is as well, to help soldiers, other service members, their family members, qualified people with civil legal needs so that the service members can focus on the mission. All right, so some of the basic protections of the SCRA. It includes a stay of proceedings, protections against default judgments. Again, those can happen, they're just very difficult. Suspension of statutes of limitations. Now, a statute of limitations is if you have a certain number of years to do something and your service prevents you from taking that action, like let's say a lawsuit for a personal injury case or a breach of contract, the SCRA can help toll or extend that statute of limitations. The 6% interest cap, which I've mentioned, lease terminations, I've also mentioned that. Cell phone contract termination, again, it may be possible to terminate a cell phone contract if you are deployed or mobilized or the service member is. And then protections against evictions, mortgage foreclosure, repossession, taxation provisions, and voting rights are also impacted or protected by the SCRA. Okay, so who receives the protections? Well, reserve members do receive protections when they are on active duty. So as a reserve component member of the military as an Army National Guard member, I can be called up to active duty or Title 10 orders is what we call them. If, for example, I am deployed, my unit is mobilized, I then become, for purposes of federal law, an active duty service member. So National Guard members are covered when they are doing that Title 10 service, or under some scenarios under Title 32, if there are certain disaster related declarations that result in service that extends for more than 30 days. The active duty Army, well, this is an Army training module, so it also applies to other branches, but active duty Army is also covered. Some protections will apply only to pre-service obligations. And then family members may also be covered. Again, family members often are impacted by deployments and mobilizations. Okay, so I've covered this as well. Overseas deployments under Title 10 status, that's all active duty. That's sometimes Guard or Reserve if they're mobilized under Title 10 orders. And if it's more than 30 days, Title 32 orders, which is that reserve component status, are also impacted. Examples, airport security after 9/11 and Hurricane Katrina. This is not in response to a state declared emergency, by the way. It must be a federally declared emergency. So if a Guard member is under, as an example, the Washington Army National Guard had a state active duty mobilization to help with employment security claims. That's public information. Governor Inslee declared that. Those types of orders are not covered even if they extend past 30 days because that was a state-specific mission. It was not in response to a federally available source of money or the federal declaration. However, the testing and tracing, if they're authorized under FEMA, if they're a FEMA-related mission, then they may be part of that federal mission, so they may be covered. But state-exclusive missions would not be covered. Okay, so when do protections begin? Entry on active duty or receipt of the active duty orders. So each order has a start date. And when do they end? Well, they normally end on release from active duty Army. There are certain areas that protection may get told or extend a little bit after release, such as the stay of civil proceedings, default judgments, the 6-year maximum interest rate as well can be extended. So enforcing SCRA rights. Well, if your SCRA rights have been violated, there is a private cause of action, and you can bring a lawsuit for damages. The court may also award attorney fees to people who need to sue to protect their SCRA rights. The U.S. Attorney General may also sue people engaged in violating SCRA. So procedural protections. This covers service members with notice of proceedings, and it applies when the service member is unavailable and their duty materially affects their ability to appear. Material effect is a recurring concept through much of the SCRA, and typically it means that the service must impact their ability to appear. In other words, we're talking about being deployed to an area where there's not good internet connection or phone connection, or perhaps a type of mission that does not allow for participation in proceedings. If it's a just regular garrison type duty station, someone's just normally under active duty orders, if they're asking for a stay, they may not get it. Again, you have to show that nexus, that their service impacts their ability to appear. But that's a stay request. It is important to follow the steps to get a stay. A stay means you want the court to pause your case. To establish a material effect, you need to have some sort of a declaration or a letter that would prove to the court by more likely than not, preponderance of the evidence standard, that the service is materially impacting the ability to appear. You do, however, have to, if you're the service member, have to give a date when you will be able to appear. And a commander needs to authorize, needs to write a letter rather, that there is no leave authorized. You do not actually have to file your orders, but you do have to have that commander's letter. So default judgments. A default judgment is if someone does not answer, then the court will grant the orders. It only applies if the service member has not appeared. However, before the judgment is entered, the plaintiff must have an affidavit submitted to the court stating whether or not the plaintiff is in the military or that they cannot determine whether the defendant is in the military. Now, the SCRA does not allow default judgments to be entered against the service member unless the court appoints an attorney first. So this is the interesting position that a lot of people find themselves in. We have a base right here in Pierce County, JBLM. Someone who is served and does not respond, and they're in JBLM, that presents difficulty because normally one would think that their service wouldn't typically affect their ability to appear, but that's the stay analysis. The default analysis is the court still has to do that work to appoint an attorney, or the plaintiff or the litigant really has to do that work to try to get the service member to respond, to appear, to otherwise engage with the court. So I've had that scenario. If the problem is service of say, a motion, you want to make sure that they know that you're going to court, you can serve through the Provost Marshal's office. You can also, if you're still having trouble, request that the court appoint an attorney for the purpose of locating that service member. Once that attorney gives a report to the court, particularly if the report is something along the lines of, oh, the service member knows about it but doesn't care, that type of report might then be grounds for the court to then enter that default judgment. But it can be very difficult. So here on your screen is the section of the code that protects service members from default and again requires the court to appoint an attorney. So if a service member has a default judgment opened against them, the SCRA also allows them to reopen it. That would be anytime you can reopen a judgment anytime that occurred, if the default occurred while the service member was on active duty or within 60 days of release from active duty. That's what that acronym is for. The service member can then reopen that default proceeding. It also applies to child custody proceedings. So if a parenting plan was entered by default, the service member could open up that default. But they have to file that motion while they're still in active duty military status or within 90 days. They have to show that the default materially impacted their ability to provide a defense, and they have to be able to assert a defense. So if there is no defense to assert, they may not be able to reopen that. Again, I've already mentioned the SCRA tolls the statute of limitations. It applies to civil and administrative proceedings and applies regardless of whether the service member is the plaintiff or the defendant. Does not apply to criminal proceedings. For tax rules, this is an important piece to notice.